Today's topic is interesting simply because at some stage or another, staff feel aggrieved in the workplace for whatever reason. Some keep quiet, some speak up, but can an employer dismiss an employee for lodging a grievance that is false or unverified? Does this dismissal amount to an automatically unfair dismissal? In this case, I'll be referring to the Labour Appeal Court had to consider if the lodging of a grievance was a right under the Labour Relations Act. And can an employer dismiss an employee for lodging a baseless grievance against another employee without it being regarded as an automatically unfair dismissal? The employee was employed by the employer as far back as 2010, and at the time of her dismissal, she was a manager within the organisation. 5 years into her employment, a meeting was held in order to resolve a contractual dispute between the employer and one of its subcontractors. This meeting was attended by the project director and the employee on behalf of the employer. Both parties openly disagreed about a contractual dispute at the meeting. The project director left the meeting before it concluded, and the employee alleged that on his way out of the meeting, the project director hit her over the head with a file. Look, we don't know what type of alleged hit she endured. The employee reported the incident to her supervisor, went to visit a doctor, and then filed a grievance against the project director. A grievance inquiry followed, which found that the assault, which was her claim, was not proven and the grievance was dismissed. After the grievance process had concluded, the employer charged the employee with misconduct and called her to a disciplinary inquiry. In the disciplinary inquiry, the employee was found guilty on the basis of gross misconduct for falsely accusing the project director of assault and for preventing other employees from performing their duties. The chairperson of the inquiry recommended that the employee be dismissed. This finding was also tested at an appeal which was upheld and her dismissal for dishonesty stood. The employee referred a dispute to the Labour Court, alleging that her dismissal was automatically unfair. She claimed that lodging a grievance was the exercise of a right under the Labour Relations Act and that she had been dismissed for doing so. The employer denied that her dismissal was automatically unfair and that the disciplinary process was instituted as a result of the grievance lodged by the employee, with specific emphasis made by her false allegation of assault made by her against the project director. The Labour Court initially found that the predominant cause of the dismissal was the lodging of the grievance and not the alleged dishonesty or false accusation against the project director. The Labour Court held that the dismissal was automatically unfair because she took action or indicated an intention to take action against the employer by exercising a right conferred by the Labour Relations Act. The employer, being unhappy with the outcome, then took the Labour Court's judgment on appeal to the Labour Appeal Court. The Labour Appeal Court found that in determining whether dismissal is automatically unfair, an inquiry into its causation must be undertaken. Factual causation is established by asking a simple question. Would the dismissal have occurred had the employee not taken action against the employer? If yes, then the dismissal is not automatically unfair. If the answer is no, it does not mean that the dismissal is automatically unfair, as we would have to go one step further and ascertain whether or not legal causation was established. Legal causation is established where the reason was the main or the dominant or the proximate or most likely cause of the dismissal. The Labour Appeal Court also held that the right to file a grievance is not provided for by the Labour Relations Act, nor does the Labour Relations Act establish grievance mechanisms or proceedings. Yes, you heard that correctly. The right to file a grievance is not provided for by the Labour Relations Act. The right to file and process a grievance is based on contract. So it's based on the employer's policies and procedures and the contract of employment. If there was evidence to prove that the employee was dismissed for filing a legitimate grievance, the dismissal would have amounted to an unfair dismissal, as it would be for a substantively unfair or invalid reason. The Labour Appeal Court found that on the facts set out in this case, no automatically unfair dismissal had occurred. The lodging of a grievance does not amount to an employee taking action or indicating an intention to take action against the employer. An employer can take action against an employee for lodging a false grievance, which could ultimately lead to the employee's dismissal. That's all that I have for you today. Until next week, ciao for now.